Have you been forced by your boss to return to the office instead of your remote working arrangements? If so, you may have legal rights that is worth considering. Why is this so important? Here's the law. You've been working from home for years, maybe since the pandemic started. Remember the pandemic? Maybe even before. Your boss just ordered you back to the office, full-time, 5 days a week, 9 to 5. You don't want to go. You feel like your life is being upended. And you're wondering, can they do this? The short answer is maybe not. In fact, forcing you back to the office after a long-standing remote work arrangement might be constructive dismissal. And that could mean you are entitled to significant severance pay if that happens. Today, we are breaking down the groundbreaking British Columbia Court of Appeal decision that changed everything and giving you a step-by-step action plan for what to do if your employer tries to force you back to the office. So let's start with the case that every employee and employer in Canada needs to know about. Cressey Construction Corporation versus Parolin, 2026 BCCA 199. This case is a game changer. Here are the facts. Tracy Parolin worked for Cressey Construction for about 18 years. She was the director of marketing. Her employment terms were largely oral. In 2013, after returning from maternity leave, she began working reduced and flexible hours, with her employer's approval, of course. During the COVID-19, she transitioned to remote work. But here's the key. Unlike her colleagues who returned to the office in June 2020, Ms. Parolin continued working from home due to childcare and healthcare considerations, again, with her employer's full support. By 2023, she was working full-time remotely with an established home office. In May 2023, things changed. Her new supervisor denied her requested salary increase, offering only a modest adjustment. Suggested her role was more aligned with a marketing manager, which in effect was a demotion. Directed her to return to the office full-time Monday to Friday, 9 a.m. to 5 p.m. Ms. Parolin treated this as a constructive dismissal and ceased working. So the matter goes to court, and at the trial judge found that flexible hours and remote work were oral terms of Ms. Parolin's employment contract. The remote work arrangement had become an essential term of her employment. The unilateral return to the office mandate imposed without reasonable notice constituted constructive dismissal. And that was the game changer right there. She was awarded 19 months' pay in lieu of notice. The Court of Appeal stage, the BC Court of Appeal upheld the trial decision and dismissed the employer's appeal. Chief Justice Meshant, writing for a unanimous court, confirmed that a long-standing remote work arrangement can become an enforceable term of employment even if it was never put in writing. The court also confirmed that a single unilateral change to an essential term like work location can be enough to constitute constructive dismissal, even without a pay cut or a demotion. Why does this matter? The decision sends a clear message. If you have been working remotely for a substantial period with your employer's approval, that arrangement may have become a binding term of your employment contract. Your employer cannot simply revoke it without reasonable notice. And if they do, you may have a claim for constructive dismissal. So let's try to understand what constructive dismissal is. Before we get to the action plan, let's make sure we clearly understand the legal definition of what constructive dismissal actually is. The Supreme Court of Canada has established that a constructive dismissal can take two forms. Form 1, single unilateral breach. This is one act by the employer that breaches an essential term of the employment contract. For example, forcing you back to the office after years of remote work without notice. So that deals with the Form 1. Form 2, a series of acts. This is a course of conduct taken together, shows that the employer no longer intends to be bound by the existing contract. So, for example, a pattern of harassment, demotion, pay cuts, and unreasonable demands all sort of congregate to form a series of acts that would ultimately constitute constructive dismissal in this case. The key element: to prove constructive dismissal, you need to show that the employer made a fundamental change to an essential term of your employment. The change was unilateral. You did not agree to it. You resigned in response to that change. You did not condone the change by accepting it. What counts as an essential term? The courts look at the totality of the circumstances. In the Parolin case, the remote work arrangement was deemed essential because it had been in place for 3 years. The employer had expressly approved it. The employer had also reinforced it by helping set up a home office for Ms. Parolin. So the employer has said as long as the job was getting done, it did not matter where she worked. The risk of condemnation. Here's where many employees make a critical mistake. If you continue working under the new terms without objecting, you may be seen as having accepted the change. This is called condemnation, and it can kill your potential constructive dismissal claim down the range. You cannot stay silent, keep collecting your paycheck, and then months later claims constructive dismissal. The clock is ticking. So, here's what you must do. Clearly object to the change. State that you're working under protest. Resign within a reasonable time if the employer does not reverse their course. Now let's get to what you actually need to do. If your employer has ordered you back to the office and you believe this may be constructive dismissal, here's your action plan. Step 1, document everything. Absolutely document everything before you do anything else. Your first job is preserving evidence. Gather and save. Your employment contract and offer letter, these show the original terms that you're working under. Emails and written communications, any mention of remote work, flexible hours, or approval to work from home, pay stubs showing your compensation and any other significant changes, performance reviews, especially if they confirm that you were meeting the expectations while remote working. Text messages and internal chat logs, any informal confirmation of your remote working arrangement is absolutely critical in this case. Witness statements, colleagues, supervisors, or HR who can confirm your remote work status. In the Parolin case, Ms. Parolin had an email from the executive vice president confirming she could continue working from home. That evidence was crucial, right? Step 2, review your employment documents carefully. Check if your contract or employee handbook contains any provisions about the employer's right to change work location, remote policies, and any other unilateral changes, temporary versus permanent arrangements. If your employer has a written policy that says remote work is temporary or subject to change, that may weaken your claim, right? Step 3, object clearly and in writing. This is the most important step. You must clearly communicate to your employer that you do not accept the change. Send a formal email or letter stating, for example, I am writing to formally object to the unilateral change to my work location. I have been working remotely since, put a date. With your approval, I consider this as essential term of my employment. Or I'm writing to continue working under protest while we discuss this matter. Further, I do not accept the change and reserve all my legal rights. This is literally preserving your legal position. This creates a paper trail that prevents the employer from arguing that you accepted the change. Step 4, negotiate. Before you resign, try to negotiate a solution. You could propose, for example, a phased return to the office. For example, 2 days a week instead of 5. Continued remote work with occasional in-office attendance, or a transition period with reasonable notice. Employers are often willing to negotiate rather than face a constructive dismissal claim. So take advantage of that and pursue that. Step 5, if negotiation fails, seek legal advice. Do not resign until you have spoken to an employment lawyer. This is so key. A lawyer can assess the strength of your claim, advise on the appropriate notice period, help you calculate your potential severance, and guide you on the timing of your resignation. Step 6, resign, but do it the right way. If you decide to resign, you must do so clearly and unequivocally. State that you are resigning because of the employer's fundamental breach of your employment contract. Do not resign for personal reasons or another opportunity has come, so I'm leaving. That could undermine your potential future claim. Step 7, mitigate your damages. After you resign, you have a duty to mitigate, meaning you must take reasonable steps to find alternative employment. In the Parolin case, the trial judge found that Ms. Parolin had reasonably mitigated her losses by pursuing entrepreneurial ventures, even though they had not yet generated revenue. So, in other words, make sure you just don't resign and sit at home, but make sure you are making an attempt to find alternate employment. But generally, you should actively search for new employment and document your efforts. Now, before we wrap this up, a note of caution. Not every return to office mandate will amount to constructive dismissal. I'm going to say that again. All right? Not every return to office mandate will amount to constructive dismissal. The Parolin decision was based on highly specific factual matrix. The remote work arrangement was long-standing, 3 years plus. It was expressly approved by the employer. The employer reinforced the arrangement through conduct. The revocation was abrupt and without notice. If your remote work arrangement was clearly temporary, subject to a written policy allowing recall, not consistently applied or approved, then a return to the office mandate may not constitute this constructive dismissal. As one employment lawyer put it, the decision shouldn't scare employers into the idea or concept that any return to the office is constructive dismissal. The bottom line, every case is fact specific. You need to assess your own situation carefully and get legal advice. So, here is the law. Here is your move. If your employer is trying to force you back to the office after years of remote work, document everything. Object in writing, seek legal advice. Do not resign impulsively. The Parolin decision has empowered employees across Canada, but you need to protect your rights. And that is how you start ensuring and making sure that all the steps we mentioned before is in place. Got it? There you go. So, constructive dismissal is available for cases where essential term of your employment contract has been changed unilaterally. Otherwise, pay attention, speak to a lawyer, and make sure you are doing it the right way. This is iChatLaw, where the law gets real. If you found this helpful, like, subscribe, and turn on your post notifications. We post every weekday, Monday to Friday, daily legal updates, daily empowerment. And if you have any specific questions, drop them in the comments. We read all our comments. And remember, if you're not sure, speak to a lawyer before you act.